Hi, my name is Goldman. I'm the director and founder of Goldman & Associates. Our firm has a primary focus on family law issues here in Michigan. And today we're continuing our video series designed to educate the public, so please subscribe to our channel. Often we are asked, what does the court consider in determining custody? Now this is a really, really good question, because people will contact lawyers and tell a set of facts. My ex did this. My wife wants that. My husband says this. These kind of things, and then therefore I want to change the custody. And what do the lawyers think? The lawyers are thinking, okay, I hear what you're saying, but these are the rules, okay? These are the things that the court looks at to determine the custody. And everything that you're telling me right now doesn't even impact those things at all. So we have to cut out that garbage and get to the real facts. So the question then becomes, and the very sophisticated client will obviously want to consider, what does the court use to determine a change in custody? Because if they start from there, if you start from that place, rather than my wife does this, or you know, my kid said that, so therefore I want to change. If you start from the place of what does the court look at, you are much likely to come up with factors that are relevant to the proceedings. How many times have you seen on TV, if you watch a courtroom drama, or Judge Judy for all I care, any of these things, how many times have you seen the court stop people and say, I don't want to hear that. I want to hear an answer to my question. It's not necessarily that the courts are trying to be rude to people. That's not it. It's that the dictates of the law require the court to consider certain things. So if people are giving a bunch of jibber-jabber about things that aren't relevant to what the court must consider, all it does is take the court's time. And the court still has to get out the other stuff, the things that are important under the statute. So it's important to realize that everything that the court considers is based on what's in the best interest of the child. And the best interest of the child is determined by about a dozen factors that the court uses that all go to the stability of the child. So when you get a person who says, I want to switch custody because I want to take my kid and move it to Florida, that doesn't really tell the story at all. Or the other way around, I want to switch custody because my ex is moving to Florida and I want my kid. That doesn't really help out, because none of those scenarios explain why is it in the best interest of the child to make a change. That's the first thing that the court is going to consider. Even before the court gets to that thing, there's another analysis that the court will do in conjunction with that, and that is, has the circumstance changed? In other words, when the court issues an order of custody, it does so contemplating that there are certain things that are going to go on in life. You don't freeze people at a certain age. The court considers, when it gives custody of a 12-year-old, the court knows that in accordance with, you know, the normal growth pattern, this child's going to get older, this child's going to get taller, the child's going to have different kinds of friends, the child is going to maybe want to do different things as he or she ages. These are all part of the considerations. So in other words, if you want to say, you know, I want to switch custody because a child is identifying with me more because now that he's older, you know, he needs his father more, it's probably not going to cut it. Why? Because when the court considers custody, the court already considers who identifies with who and what will likely be the scenario. And it's not likely to fashion its orders based on the whimsy of a teenager. Okay, the court's going to need a lot more than that. So, you know, it's a perfect example of things that you've got to know what the court considers. So the court is basically going to look at things that go to the stability of your kid. The best interest is served if the child's environment is stable, and if it's an environment that's stable and promotes the healthy nurturing of the child to become a reasonable and respectable member of society. The factors are all designed to go through that. Now, without going into the 12 factors, your lawyer can sit you down, and even in our firm, we give people a copy of the statute, and we show them these are the factors. So this is what you got to concentrate on. These are things we need evidence on. But without going into the individual ones, I will tell you that when you want to know what the judge is considering, he or she's only considering what's in the best interest of the child, doesn't care what's in your best interest or the best interest of your ex. That's not what he or she's supposed to determine. Only goes to those things, and those things are about stability and raising the child in a healthy way. Those factors are very specific though, and if you want more information about those as it relates to your case, reach out, of course, and we'll be glad to help you out.